Good morning. I'm Judith Waltz. I'm a partner with Foley Lardner in the San Francisco office. I'm co-chair of our healthcare group, which is about 50 people at this point, and practicing in various areas of healthcare law. The reason that Faraz and I are here today, and Faraz, you will hear from him in just a minute, is that we are co-editors of the book, the AHLA Federal Healthcare Laws and Regulations. This is published every year. Some years it's just published as a supplement. Other years it's published as a 3-volume set, which you can see behind Faraz's shoulder there. This year it's in a beautiful purple. And on the reason I want to call this to your attention, first of all, explains how we ended up in this podcast. But secondly, on the cover, it says dedicated to William Horton. And I want to make sure that everyone knows who William Horton was. As you might imagine, he's no longer with us. He died last year. He was the editor of this publication for many years, including until his death last year. He was very involved with AHLA. He was just a wonderful person and just very smart, often delivered the ethics sessions because his sense of humor made everything just very amusing. And for ethics courses, that can often be a real challenge. So we missed him dreadfully, and just want to make sure that he in the past has co-hosted this and really moderated it. So we're missing him on several fronts today. So our point today about what we're discussing is some of the topics that were within the areas that Faraz and I covered as co-editors of this publication. So Faraz will tell you about his section. Mine was the Medicare and Medicaid updates. And as you might imagine, that is never despite all the problems with congressional legislation, there's always a lot in the Medicare space. And we look at the things that have been added over the years and deleted on occasion to decide what should be included. So with that, I'm going to turn it over to Faraz, and he's going to introduce himself, and he's going to start with his part, and then we'll be back to me. Faraz?
Thank you. Thank you for that, Judy. And thank you to AHLA for bringing us together to have this conversation. Judy, thank you for the beautiful words dedicated to Bill. We will miss him. And I know our audience and readers will also miss him. As a disclaimer, everything that we are providing in this podcast is for informational purposes only. This is not legal advice, and from either myself or from Judy, and our information that we provide over here does not constitute attorney advice or an attorney-client relationship between us and the listeners. So, as Judy mentioned, both of us are editors of the AHLA, this AHLA book, and over the course, year after year, we look at the various federal regulations and laws that have changed and get an overarching view of how the laws in our respective areas are being developed. Myself, I'm an associate at Hyman Phelps McNamara. We are the largest FDA-focused law firm. My personal practice is with clients who are manufacturers, distributors, and sponsors of clinical trials for drugs. I work on government pricing and reimbursement issues. I do a little bit of fraud and abuse work. And I also help advise clients on drug development issues before approvals of drugs or biologics. I help them with post-approval compliance issues as well, such as advertisement and promotion, and post-approval reporting to the FDA. So I work on both FDA laws. For this publication, I update both the FDA laws, so that's Title 21, both of the U.S. Code and the Code of Federal Regulations. And because of my practice in government pricing and reimbursement, I thought I'll also share some updates with you on that side. So the Inflation Reduction Act, for example, is a big issue. What Judy and I thought to do is just go over some of the bigger changes, the most significant changes that we've seen from in 2023. Of course, there are probably many different laws that affect our clients or others, our listeners, in many different ways. We had to pick some that we think are both, were important for 2023 and may have some further developments next year. In 2024 and beyond. I will break up my personal comments into the more FDA focused issues and then the more of the government pricing related issues.
Sounds good for us.
Perfect. So in I asked some of our colleagues who work on the drugs and then some of our colleagues who work on the device side to tell me about what were the most significant changes that they've seen. And on the devices side, we have seen a proposed rule as recently as in October with relation to lab developed tests, LDTs, laboratory developed tests, which are a type of in vitro diagnostic. There's a proposed rule that the FDA put out in October, and it's been all the rage in the device community. There've been a lot of comments that have been put in for the proposed rule. So maybe I can give a little bit of a background on what these in vitro diagnostic tests are, just to get people to help people catch up on that. I think all of us have used COVID tests recently. But there are several blood tests and other kinds of tests that are developed within a single laboratory, and they meet certain requirements, certain lab requirements, but there are regulations, and whether they are subject to the FDA regulations has been up in the air. FDA has long claimed that they are implicitly covered under the device regulations because they are devices, the FDA argues. But there hasn't been any, there wasn't any specific law or regulation, a clear basis for this claim. So what the FDA has done for several years is state that they are covered, but then cover all lab developed tests under an enforcement discretion policy. So there haven't been a lot of FDA related requirements for them in past years. So in October, after many years of flipping and flopping, many years of keeping the industry in suspense, FDA published a proposed rule. The actual change that it will do in the regulations will be just 10 words, a very small, short change. What it does is that in 21 CFR 809.3 for people who want to see the particular regulation that'll change. That regulation is the regulatory definition of in vitro diagnostic products. This will include at this point, if this proposed rule is finalized, it will include the words, quote, including when the manufacturer of these products is a laboratory. And by those 10 words, it will include all laboratory developed tests as in vitro diagnostics. Once that happens, what the agency has said is the enforcement discretion that it has applied so far will expire, but the agency gives manufacturers 4 years until it expires. It will take a little bit of time. There will be a very narrow set of enforcement discretion policies that FDA may still maintain for some of these tests, but by and large, after 4 years from this finalized rule, if it is finalized, all lab developed tests will be subject to the device regulations such as registration and listing, pre-market review, post-market reporting, quality system regulations, and really bring that level of scrutiny from the agency to that work. And
so Faraz, I have a question, and I always hesitate to ask questions because I know part of the answers. So I don't want to sound like I'm a total idiot. So take the question with a grain of salt. These LDTs fascinate me, frankly, because I understand that labs use them to develop tests and basically outside of the FDA, the long process that it takes for approvals and all of that, they're really creative things you can do. But the limitations to one lab only intrigues me as well. And does that mean that lab controls the test, so it licenses it out? Or what if it's a big, I work with a lot of esoteric labs. That's the labs that do specialized testing, esoteric being kind of a euphemism, but they have one lab, in the country. They have clients all over the United States. But what about those places that have multiple labs? Can they develop an LDT in one of those and then use that for all their labs? How does that work in theory?
Yeah, so usually what happens with the LDTs, the reason why they are carved out as a separate piece within in vitro diagnostics is just to allow a particular one single lab to do it. This is sort of a just a theoretical cutoff in here to allow single labs who have been working with a particular reagent, a particular reagents or particular diseases to go ahead and develop these tests. But there might be, well, I don't do as much device law as some of my colleagues, but I do know that when there are multiple labs that are developing a test, some additional regulations come in. For example, if there are parts of a test that are developed in one lab and then they are shipped to other labs, there is some sort of inherent distribution that's taking place. There are some additional FDA requirements that can tack on to those labs, and FDA could have more reason for claiming jurisdiction over those when they're all over the country. So generally what happens is FDA has in the past kept the single lab part of this within its definition of laboratory developed tests to talk about this specific kind of test that it sees as a little bit different and historically not included within the framework that it has set. Yeah.
Thank you.
Yeah, so those overall, this I think is one of the most significant changes that we have seen in 2023. And I know later on we'll talk a little bit about what we will look forward to in 2024. So I can share a few more insights into how we think things will shape up in 2024 going on. The other big piece from an FDA point of view has been the developments in accelerated the this law called FDORA, the Food and Drug Omnibus Reform Act, FDORA, was enacted at the end of 2022. So I think it was like December 29th, right at the end. So, most of the implementation that we've seen for that has been in 2023. There were a couple of changes that made in 2023. The accelerated approvals is one that I'll talk about, and modernizing clinical trials has been another main piece. So accelerated approvals for drugs and biologics, the FDA has the ability to grant early approval for diseases, for drugs that treat serious conditions and have an unmet medical need. So for such, more, I would say like more severe diseases, but there's a statutory requirement on exactly what kind of diseases these can that can get accelerated approval. What the FDA does is review applications based on a surrogate endpoint. So we have diseases such as certain cancers, like Alzheimer's, that develop over many years or sometimes many decades. And to do a clinical trial that looks at the ultimate clinical benefit of a drug could be unfeasible to take them sometimes 10 or 15 years just to try and see exactly how many people achieved a clinical benefit or not. So there are some surrogate endpoints that the FDA has developed. Manufacturers have developed and backed up with research and use to submit applications to the FDA. So, for example, in the cancer space, one of the surrogate endpoints could be whether a tumor was shrinking or not by the time that it was measured. So the manufacturer says that these markers, like the shrunken tumor, is a surrogate endpoint and can predict clinical benefit. The condition for getting an accelerated approval, though, is that the drug sponsor must commit to conducting one or more post-approval studies. Some studies have, so sometimes what it is, it's the study that's going on that's extended beyond the approval date. Sometimes it's new studies that need to be done. But what ultimately needs to be done is that the clinical benefit of efficacy needs to be confirmed in these trials. A couple of years ago, in 2021, there was an Alzheimer's drug that was approved, even though the advisory committee and a lot of experts in the Alzheimer's space said that the data just was not there. It wasn't strong enough that we should not, the FDA should not have approved it. And it was approved under an accelerated program. So since then, and sometimes even before then, the entire program came under scrutiny. So at the end of 2022, Congress made some changes in the law. It gave FDA the ability to hold drug clinical trial sponsors to more accountability in going through with these post-approval studies, and gave them a few more enforcement powers. So I can go into a little bit more details, but wanted to just stop over here and check, Judy. You know, there are like, is there some more background that I can share on this on the program in general before getting into some of the more details?
Well, I'm just wondering if the accelerated process was in some respects a response to the debacle with the Alzheimer's drugs that were approved and one thing and another. And maybe you can just tell us the short version of that story and where things stand now. I mean, those also have reimbursement connotations.
That's right. Yeah. So the accelerated approval program has been around for a long time. But you're absolutely right. These changes, many believe, were a direct result of all the scrutiny that the FDA faced around that. What happened is when the FDA reviewed the application for this Alzheimer's drug, there were some issues that the reviewers revealed, in that review they talked about, they discussed some issues with the data where the full efficacy was not shown, or the efficacy was clear only in a smaller subset of the research subjects. So when they looked at it as a whole, the advisory committee looked at the application as a whole. They did not think that this is something that should be approved. However, there was, there were other reviewers that had some positive data that they saw, and overall, the agency decided that this is something that should be approved. And with the accelerated approval program, they thought that some of the data that was missing could probably be gathered and will show up as this trial continues after until the drug gets a full approval. But experts and other critics of the FDA said that, look, there just isn't enough for this drug to go out and patients to start getting treated by it, especially because the drug also had a very high cost. So a lot of payers, just like you said, from the reimbursement side, a lot of payers looked at the data themselves and said, hey, you know what? We just don't think that the data is there. We don't want to pay for this when we don't think that it will be efficacious for the patients that it's prescribed to. So what ended up happening is a lot of the major payers said that they're not going to cover it. So instead of going after just that one approval and talking about how that thing should have been different over there, both the FDA and Congress thought it's a good time to look at the accelerated approval program as a whole, because this drug might have brought some issues to the fore, but prior to this, there were other approvals that had some data that wasn't as strong as other data. And as it turns out, the post-approval confirmatory studies were not being done in every instance. There were significant delays and sometimes outright failure to conduct those studies. And that started garnering a lot of criticism of the program as a whole. FDA also did not have enough powers. They just had limited options to enforce the requirement to conduct these tests, to conduct these trials. So because of all these shortcomings of the program, Congress gave FDA a little bit more authority on how it reviews the applications under the accelerated program, but more so how it enforces the requirement to do these post-confirmation studies. So what happens is, or what FDORA, the law, changed at the end of 2022 is that FDA can now require a manufacturer to have a post-approval study already underway prior to even getting that approval. Or sometimes they can say, you know, within such and such a time, within a specified amount of time after approval, you have to have started this study. FDA can also, or rather FDA must specify conditions of what this trial should look like. So they can say, you know, they can give some enrollment targets, some milestones to reach, and a target date for study completion. FDA has also can also now ask regular reports on these trials. In the past, there were some annual reports that were due. Now these reports will be due every 6 months so that the agency can keep up with what's going on with these studies. And if the drug sponsor is not undertaking these studies with due diligence, as the statute says, FDA has new enforcement powers. The failure to conduct a study can allow FDA to initiate these enforcement. And even sometimes, you know, if a drug sponsor doesn't submit one of these biannual reports, FDA can say that, you know, you're not being diligent with the study and can theoretically initiate these enforcement action.
You know, just to interrupt again, there's a similar concept on the Medicare side for reimbursement called coverage with evidence-based development that I think is really very cool. So it's a way, if there's a drug or product that is showing real promise based on the studies, Medicare will say, okay, we will cover it, but you have to do these studies that would be specific to Medicare beneficiaries who are receiving the product, which is brilliant in many respects, I think, because you get a product into circulation or availability for Medicare beneficiaries much sooner, and then you can encourage demographic specific information. So you're going to see, does this work for people in the Medicare, you know, database, demographic base, or is this something that maybe only works for 20-year-olds based on the studies as opposed to 65-year-olds? So it's a way of trying to keep safety in place and efficacy, but getting things into use maybe a little bit sooner.
Yeah, and I think that has been the point for this for this pathway. You know, especially for it's being used a lot in the cancer space, as I was saying earlier. You know, there are people who need this and can't wait for a much longer study to be done and much you know, for that sort of data to be developed after that. So it definitely has been very helpful for patients. And FDA has been trying to reach that fine balance of having things out there for patients to use, but at the same time, making sure that they are safe and effective enough. So yeah, this law, we think, will ensure that the accelerated approval program is doing what it was originally set up to do, you know, to allow products to come into the market a little bit earlier. FDA has set up an within the statute, it required FDA to set up a committee within the agency, a council that will look through different surrogate endpoint. You know, the agency will think about new diseases that can come under this pathway, publish guidance on new surrogate endpoints, and really streamline and standardize how the agency should move forward in this. So I think strengthening this program will allow patients to get disease treatment sooner, and then eventually make sure that those diseases are actually safe and effective.
So Faraz, maybe I'll talk about some of the Medicare developments from the last year, and then we'll come back to you for some predictions on themes for the upcoming years. So one thing I do want to note with respect to the Medicare sections that I reviewed, we originally were focused on things that would be updated in the books that were here as co-editors and to discuss. But with respect to Medicare, the regulations are often finalized. The very significant ones are finalized after those books come out. So the books are current through about May. And then, of course, the physician fee schedule rule and many of the other major rules are actually proposed and finalized after the book comes out. So I will say that as a caveat, do check for the latest version in ECFR, but as a regulatory lawyer, I use both the hard copy and the ECFR, and I think it's just in working with junior associates, I think seeing visually how things are laid out as opposed to more targeted approaches will give you a much better way to analyze issues. So with that, I'm going to focus on the last year, so not the prior year up to May, but this more recent year and the things that I think are really significant in terms of big steps forward for Medicare. And one thing we have to remember as well, this was the year that the PHE ended. And so there was a lot of stuff that had to be changed and not changed and figured out what was going on with all of this. And I have to say, I think it was almost like the Y2K with the predictions of disaster. Y2K, for anybody who's too young to remember, was when the millennium changed and everyone was afraid our computers were going to implode somehow. And of course, that blew over without too much concern. And from my perspective, people have been able to, including CMS, have been able to accept the PHE and move forward. And that, frankly, seems pretty smooth. Some things have stayed behind. Congress has intervened on some. But anyway, overall, I think the process has been smooth. So from my perspective, these are the three biggest developments from the last year. And admittedly, my practice is probably more focused on Medicare than maybe some people on this who are listening in. Enrollment, Medicare enrollment sounds like a very dry and boring topic. It is CMS's approach now to enforcement. And so it needs to be watched very carefully. Each year, there are additional provisions that are coming in through enrollment that need to be factored into your strategy in terms of enforcement and compliance. So I'll give an example from this year, and that's that now if an entity enters into a false, not enters into, if an entity goes to trial on a False Claims Act case and loses, and there's an award to the government as a result of that losing, not a settlement, but an actual post-trial judgment, that can be reasons to deny Medicare enrollment going forward. And so, if occasionally I work in this space, and occasionally people are very convinced they can win a case, but this is just another thing you have to put in there is, the cost of litigation and then the risk that you might lose. If you lose, you could be kicked out of Medicare, much the same way that you could be excluded. There are other provisions that were added in through enrollment as well, including, for example, in the hospice space, that a medical director has to be enrolled in Medicare to sign their certificates of terminal illness, and otherwise all of those claims will be disallowed. So these are the consequences here are much more than filling out a form. They need to be considered. Another thing that I think is very important this year, big step forward for Medicare, is that they are going to allow additional categories of mental health professionals to be billing providers, which means they don't have to be under the supervision of someone else. They can bill in their own names. This includes marriage and family therapists, which in California is a very big, there are a lot of MFTs here in California, and this hopefully will improve access to mental health services for Medicare beneficiaries. So that this, I think, is just a huge recognition of both the need for these services and the ability of these people to provide services that are needed. My third of my top three has to do with Medicare Advantage. And this was, in many respects, characterized as a clarification, which is always a buzzword when you look at I won't go into that now. Whenever there's a clarification, it's like a red flag to look at exactly what is happening. But CMS has indicated that they are going to require and expect of Medicare Advantage plans that they will be providing services in the same way that they would be provided to Medicare Part A and Part B beneficiaries, which means if Medicare says a particular service has to be performed as inpatient only, for example, that rule will apply to the Medicare Advantage plan as well. And certain levels of practitioners, if there's a requirement that the service be performed only by a physician, then that's not going to be good enough for just some other types of practitioners. So to me, this represents a major again, we'll go back to the CMS word clarification, but this really will constrain some MA plans in terms of their innovation and cost cutting, because they will have to provide services that are provided in the same manner as you would under parts A and B. So Faraz, I'm going to turn it back to you to talk about what you think is coming up in the next year.
Yeah, and I'll try and be a little bit more brief, because there are, as we were discussing before this call, before this session, so many things that have been changing and continue to change. So, I think I'll switch gears a little bit and talk about some of the changes under the Inflation Reduction Act that we are going to see come in the next year. The big theme over here is continued pressure on decreasing drug prices. There is a bill, there's some bills being discussed in Congress on increasing transparency for pharmacy benefit managers. So we'll see how that how that falls out. Next year, 2024 is a election year, so we'll see a lot of back and forth in terms of which side has what plans. So that's one thing to look out for. A lot of the laws that were created under the Inflation Reduction Act are also in full gear, started in 2023, and we'll see some of those implemented in 2024. So just to list some of them in brief: Medicare drug price negotiations. The negotiation will start in around February of next year, and the maximum fair price will be published in September, on September 1st, 2024, and then will take effect in 2026. But this will be that first set of negotiations that CMS will undertake. Mind you, there are several lawsuits that the manufacturers of the drugs that have been selected from negotiations have already filed in various district courts. So we might see some changes to the negotiations program as some of those decisions are made in court. In 2023, we also saw the inflation penalties, the inflation rebates for Medicare's Part B and D that was set in. So some of those will continue. CMS released some revised guidance on those inflation rebates. And just for those who do not know, these programs penalize manufacturers of certain drugs that raise their prices faster than inflation. We will also see continued developments on a manufacturer discount program under Part D. Part D has a lot of changes coming in starting in 2025. And so some of those details are being ironed out by CMS guidance. Finally, on the Medicaid side, again, this is more for manufacturers and distributors than for practitioners and providers. There have been some major changes proposed by Medicaid earlier this year, including some price transparency laws, what's called the best price stacking rule that's been proposed. And some of these questions have been up in courts also. So we'll see how CMS, how and whether CMS finalizes some of those rules. They did receive a lot of criticism on some of these particulars. So we can go into more details if we have time, but I think those are some of the things to look out for. Medicaid final rule, whether Medicaid will finalize its rule that it proposed earlier this year on the Medicaid program.
So let me just talk about my top 3 or 4. Some of them could fall into both categories, and they dovetail with one that you. So anyway, I'm going to go through through my priorities here for the coming year, things that I am watching. First of all, CMS's focus, and DOJ's as well, on private equity investment in healthcare just seems to be more and more pervasive. Even in the enrollment regulations that I mentioned, there's a discussion and things I've never seen CMS go to this extreme on, quotes about the quality of care in facilities that are owned or operated by PE. And CMS is now requiring more transparency in terms of who is in an ownership or controlling position with respect to nursing homes in particular. And there was a Senate Finance Committee meeting recently as well on regulating hospitals. So I'm watching this. I'm not sure if CMS's end game, because if PE was not interested in healthcare, I'm not sure who steps in to pick up that role. So certainly we all want quality healthcare for everyone, but the focus on PE is surprising to me, and its intensity seems to grow in quite a respectable trajectory. The other thing that I am watching has to do with relationships that DOJ is looking at. Maybe this is somehow related to PE, but more in the context of business structures. So MSOs, marketing arrangements, things of that sort, where OIG has been looking at and the OIG regs were also in my purview and statutes, although there weren't many changes in that respect in the last year. But those relationships have been scrutinized for potential veiled kickback arrangements. And I think we all recognize that healthcare is just changing in its delivery process. And some of these structures have come up to address certain problems that have come up. So related to this, and this is why I say I'm not sure if there's 3 or it's 4, has to also do with the physician-patient relationship. If you read the recent, in my spare time, I read indictments and complaints and things of that sort. I find them fascinating in the way to really figure out where DOJ and OIG are coming from on all of this. There's been a real focus on a need for a physician-patient relationship that's more than just a physician signing off on a lab order, for example, or a medication order. And that is in some respects contradictory to a different movement going on, outside of Medicare, but just in our society, which is more self-directed medical care. We have the internet, and people think they can figure out what's wrong with them or what drug they want to try, or maybe they should be tested for a certain food allergy. And the idea of the physician as gatekeeper and all of this, while we're talking about Medicare, which can direct its beneficiaries however it wants within limits, this is all very, very fluid, I think, at the moment. And with discussions of cash pay, does cash pay get you out of those concerns, or you can just pick out your own lab menu and get some doctor to sign? Anyway, I think those are going to be trends to watch, and I don't think there are clear answers as to how that relationship is going to develop. And so my final one has to do with cost controls, and this sort of dovetails back with what you were talking about, Faraz. Medicare historically has not based coverage determinations on cost, and it still is not doing that directly, but the things like you're talking about with the IRA in terms of Part B negotiations, and then you talk about, PAMA reimbursements, PAMA being Lab Protecting Access to Medicare Act, which at some point, if it ever is fully effectuated, could result in a reduction in the amounts of payment for Medicare lab tests. There are a lot of things that are going on right now where Medicare is in fact struggling with how to control these huge costs, which is a concept that historically they had not. And I can dig up something from 25 years ago or so that says we do not consider costs when we think about coverage.
Yes.
And that is deeply buried now in terms of what products CMS will cover and then what they will pay for. So that's a real struggle, I think, for Medicare that we're going to see. So Faraz, I think we're getting close to the end of our time. Do you have any final comments you want to make?
I think as co-editors, we know that we have others also who cover different parts of the federal laws and regulations. We've seen how expansive healthcare rules and laws are, how they touch everything from the tax code to antitrust issues to as you talked about Medicare Advantage, Medicare and FDA work. Things keep changing. I sometimes I can't keep up, and it's nice to be able to talk about some of them today. But as most people who are listening know, this is a constant and very dynamic, constantly changing area of the law.
So I'm going to just thank you all for listening to us today. We very much appreciate it, and hopefully you will find the book book set of 3 to be useful as well. And I think I speak for Faraz and certainly for myself. If you have questions about anything we were talking about today, feel free to reach out to us. You can find us through the AHLA directory.
Yes, thank you everyone for listening, and hopefully we can meet again.
Thank you.